Most people believe their home is protected by the Fourth Amendment from unreasonable searches and seizures. The assumption is simple: police need a warrant to enter. But what if that assumption is wrong? What if there are situations where law enforcement can legally walk through someone's front door without ever setting foot in a courthouse or speaking to a judge? The reality is far more complex than most people realize. While the Fourth Amendment does provide significant protections, it also contains exceptions that can be surprising and sometimes shocking to the average citizen. These exceptions aren't loopholes created by clever lawyers or corrupt officials. They're established legal principles that have been tested in courtrooms across the country for decades, shaped by real cases involving real people whose lives were forever changed by a knock at their door. Understanding these exceptions isn't about becoming paranoid or distrusting law enforcement. It's about being informed about one's rights and the circumstances under which those rights might be limited. The difference between knowing and not knowing these rules can mean the difference between evidence being admissible in court or thrown out, between a conviction and an acquittal, or between a lawful police action and a violation of constitutional rights. The concept of warrantless entry begins with what legal experts call exigent circumstances. This term describes emergency situations where waiting for a warrant would either put people in danger, allow evidence to be destroyed, or let suspects escape. These aren't theoretical scenarios dreamed up in law school classrooms. They happen every day across the United States, and they've been the subject of countless court battles that have shaped how these rules are applied. One of the most straightforward examples involves hot pursuit. When police are chasing someone who has committed a serious crime, they don't have to stop at the suspect's front door and wait for paperwork. If officers are in continuous pursuit of a fleeing felon, they can follow that person into a private residence. This principle was established in a 1976 Supreme Court case called United States v. Santana, where officers chased a drug dealer who retreated into her home during an attempted arrest. The court ruled that she couldn't defeat an arrest by simply running inside. But hot pursuit isn't just about dramatic car chases ending in someone's driveway. The concept extends to situations where officers are following up on crimes that just occurred. If police respond to a domestic violence call and the suspect flees into a house, they can pursue. If someone commits an assault and runs home, officers don't have to let the trail go cold while they seek judicial approval to continue their investigation. The timeline matters enormously in these situations. Courts have ruled that there must be immediate or continuous pursuit. If officers lose track of a suspect for several hours and then show up at their residence, that's no longer hot pursuit. The emergency nature of the situation has passed, and normal warrant requirements apply. This timing element has been the deciding factor in numerous cases where evidence was either admitted or suppressed based on how much time elapsed between the crime and the entry. Another major exception involves the destruction of evidence. Police can enter a home without a warrant if they have reasonable grounds to believe that evidence is being destroyed or is about to be destroyed. This exception gained significant attention in a 2011 Supreme Court case called Kentucky v. King, where officers smelled marijuana coming from an apartment and heard sounds they interpreted as evidence being destroyed after they knocked and announced their presence. The evidence destruction exception creates a fascinating legal puzzle. How do officers know evidence is being destroyed if they can't see inside the home? Courts have accepted various forms of indirect evidence: sounds of toilets flushing repeatedly, running water for extended periods, the smell of chemicals associated with drug manufacturing, or even suspects making statements about getting rid of things. The challenge for law enforcement is that they must be able to articulate specific facts that led them to believe evidence was being destroyed, not just general suspicions. This exception has led to some controversial situations. In some cases, the very act of police knocking on someone's door has created the emergency they then use to justify entry. Critics argue this creates a dangerous precedent where law enforcement can essentially manufacture their own exigent circumstances. Supporters counter that criminals shouldn't be able to simply destroy evidence while officers wait outside with their hands tied. The third major category involves immediate danger to life or safety. This encompasses situations where officers reasonably believe someone inside a residence is in imminent danger of death or serious bodily harm. Unlike the other exceptions, This one isn't necessarily connected to criminal activity. Police might enter to stop a suicide in progress, to provide emergency medical assistance, or to protect someone from domestic violence. The danger exception has been invoked in cases involving everything from gas leaks to medical emergencies to ongoing assaults. In 2006, the Supreme Court addressed this in Brigham City v. Stewart, where officers entered a home after observing through a window what appeared to be a fight in progress. The court ruled that officers don't need to ignore ongoing violence simply because it's happening on private property. What makes this exception particularly complex is the requirement that the danger be immediate. Police can't enter because they think something bad might happen later, or because they're generally concerned about someone's welfare. There must be specific, articulable facts indicating that someone is in immediate jeopardy. Courts have spent considerable time parsing what constitutes immediate danger, and the answers often depend on the specific circumstances of each case. Beyond these three major categories, there are several other situations where warrantless entry is legally permissible. Consent is perhaps the most straightforward. If someone with authority over the property gives permission, no warrant is needed. But determining who has the authority to consent can be complicated when dealing with shared residences, landlord-tenant relationships, or family situations. The concept of plain view also plays a role. While officers can't enter based solely on what they see from a public area, what they observe can provide the justification for one of the other exceptions. If police see illegal activity through a window, that might establish probable cause for believing evidence is being destroyed, or that someone is in danger. Administrative entries represent another category entirely. In certain regulated industries or situations, the expectation of privacy is diminished, and warrantless entries may be permissible for inspection purposes. This doesn't typically apply to residential properties, but it shows how the Fourth Amendment's protections can vary based on context and circumstances. The consequences of these exceptions extend far beyond the immediate police action. When officers enter a home without a warrant under one of these exceptions, anything they discover in plain sight can potentially be used as evidence. This means a warrantless entry justified by one concern might lead to prosecution for completely different crimes. Someone whose home is entered during a medical emergency might find themselves facing drug charges if illegal substances are visible to the responding officers. Courts apply what's called the exclusionary rule when evaluating evidence obtained through illegal searches. If a warrantless entry wasn't justified by exigent circumstances, any evidence obtained as a result typically can't be used in prosecution. This creates powerful incentives for both police and defense attorneys to carefully examine the circumstances surrounding any warrantless entry. The practical implications for citizens are significant. Simply being inside one's home doesn't guarantee protection from police entry. The circumstances surrounding the situation, the nature of any suspected criminal activity, and the specific facts known to officers all play crucial roles in determining whether entry is legally justified. Understanding these rules also helps explain why police behavior might seem inconsistent from one situation to another. Why do officers sometimes wait outside a house for hours, while other times they enter immediately? The answer often lies in whether exigent circumstances exist and how officers assess the specific situation they're facing. Training plays a crucial role in how these exceptions are applied in practice. Police officers must make split-second decisions about whether circumstances justify warrantless entry, often in stressful situations with incomplete information. Departments invest heavily in training officers to recognize when these exceptions apply and when they don't, because mistakes can have serious legal consequences for both the officers and any resulting prosecutions. The technology age has added new wrinkles to these long-standing principles. What happens when officers use thermal imaging to detect heat signatures that suggest marijuana growing operations? What about using drones to observe private property? Courts are still working through how traditional Fourth Amendment principles apply to new investigative techniques, and these decisions will shape how warrantless entry exceptions evolve in the future. Different jurisdictions sometimes interpret these exceptions differently, leading to variations in how they're applied across the country. What might justify warrantless entry in one state or federal circuit might not in another, at least until the Supreme Court provides definitive guidance. This patchwork of interpretations means that understanding local precedents can be just as important as knowing the general principles. The balance between public safety and individual privacy rights remains one of the most challenging aspects of American law enforcement. Each warrantless entry exception represents a decision by courts that the immediate need for police action outweighs the privacy interests of property owners. Critics argue these exceptions have been expanded too broadly, while supporters maintain their necessary tools for effective law enforcement. Recent years have seen increased scrutiny of police practices, and warrantless entries have become part of broader discussions about police accountability and constitutional rights. Some jurisdictions have imposed additional restrictions beyond what federal law requires, while others have maintained more permissive approaches. This ongoing evolution reflects the continuing tension between security and privacy in American society. The human cost of these legal principles extends beyond abstract constitutional theory. Families have had their homes entered by police, sometimes leading to traumatic experiences even when the entry was legally justified. Communities have been divided over police tactics, and individual lives have been forever changed by split-second decisions made by officers operating under these exceptions. For anyone seeking to understand their rights, the key takeaway is that the Fourth Amendment's protections are strong, but not absolute. The home receives the highest level of constitutional protection, but that protection can be overcome by specific, compelling circumstances. The difference between lawful and unlawful police conduct often comes down to the specific facts of each situation and how those facts fit within established legal principles. The next time you hear about police entering a home without a warrant, pause to consider what emergency circumstances might have justified that entry.